Hi, good afternoon. I'm Shannon with the Shannon Jones team at Keller Williams Realty, and we are joined today by Linda Dunn with Western Law Group, and they specialize in both landlord tenant law and real estate law. And in light of our whole world being impacted by COVID, landlord tenant laws are no different. And with AB 3088 passing last week, we thought this was a good opportunity to catch up with Linda and get some questions answered that we're hearing from a lot of people. So thank you, Linda, for joining us today.
Yes, thank you for having me.
Great. So tell us a little bit about how COVID has changed landlords' rights and tenants' rights, and what the impact is of the law that passed last week, 3088.
Sure. So up until last week, we had different levels of government having their own regulations. So a lot of things were varying city to city, county by county. With the state coming in, what they've done is that they've now governed statewide what the laws are. And they've changed the laws as it relates to non-payment of rent, evictions for tenants, as well as other various landlord tenant rights, so to speak. So the easiest way to look at it is that AB 3088 has divided rents for 2020 into two different sections. We have rents that have accrued March through August, and then we have rents from September through January 2021. And so the state law treats those differently now.
Okay. And so, so does this supersede any of the city and county rules that were already in place?
For the most part, because the majority of cities and counties have laws that are less restrictive than they are now. So those
Okay.
less restrictive laws are gone and the statewide governs. Unless you're in a rent controlled area, places like Berkeley, Oakland, LA, where they have rent boards, and those are more strict, and you have to adhere to those.
Okay. All right. Great. So, with 3088, what happens? And, I think sometimes people think, that, well, landlords have all this money, but a lot of landlords are, mom and pop kind of property owners who maybe own, one unit or just a few units, and they have a mortgage and they're not able to make that mortgage if the tenants aren't paying rent. And obviously a lot of people have been financially impacted. So what happens if a landlord can't pay the rent?
Well, so if
if a tenant can't pay the rent, what does a landlord have in terms of an option?
Right. So if a tenant isn't paying rent, then their option right now is for those monies that are unpaid between March and August. What they need to do is they need to give notice this month before September 30th. That is a 15-day notice that puts the tenant on notice of here's how many months of rent you owe, here's how much it is. And now you have 15 days to tell us, have you been financially impacted? If so, you need to sign off on this declaration that is under penalty of perjury, that they sign off and say, yes, I've been financially affected due to the COVID, the shutdown, whatever it may be. And if they do that, the biggest thing that AB 3888 does is that money that is owed now becomes what we call a consumer debt, which means it could never be subject of an eviction, and that could never be the reason why you evict a tenant, whether that's now in 2020 or next year in 2021. Any money that accrues from March through August, you can only file in small claims court. Even if they owe you over $10,000, because small claims court says usually you only can file up to $10,000. But now they've changed it to where even if it's over $10,000, You can only file in small claims court for that money.
Okay. So basically, if they're impacted by COVID and they're not paying rent, they can still go after the rent, but they cannot remove the tenant basically at this point.
Right, exactly. And even when they go to file the small claims case, they can't file that until March of 2021.
Okay. So there's like a kind of a grace period, if you will, for the tenant.
Right, exactly.
Okay. And so then that leaves the landlord or the property owner to need to kind of deal with their bank if they have a mortgage on the property.
Right, right. And so, yes, they would need to deal with their mortgage holder, whoever that may be, and supply them with the declaration that the tenant signs off on. Since that's now state law, that's going to be helpful to those homeowners with their banks saying, look, they gave me this declaration that they've been affected and that's why they're not paying.
Okay. And what counts, what kind of exactly documentation then does the tenant need to provide kind of showing that they can't pay rent? What does that look like?
So that's a good question. What AB 3088 has now done has said if you owe this rent, you're not obligated to supply documentation.
Oh, okay.
The only thing you do is you sign off on this declaration, which is under penalty of perjury. So if we decide to evict them next year for their non-payment or for some other reason, or you go to small claims court and it turns out that it's not true about them being financially impacted, that can be used against them because they declared under penalty of perjury and they've now committed perjury, right? So that's really all you have. The exception to that rule is high income tenants. High income tenants, as defined under the new law, is those people making 130% of the median income for that area. And they provide you with a chart that says, here's what median income is, here's what 130% of it is. But if your tenant doesn't fall under that, then technically the only thing they need to supply you with is the declaration.
Okay. What if a landlord doesn't know if their tenant falls under that income category? I mean, let's say, if the tenant moved in a year ago or something, then presumably they filled out a rental application and they probably have that income information. But let's say it's a tenant who's been there for, I don't know, 5 or 10 years and they've changed jobs and their income has changed. How can the landlord tell?
So a landlord can ask the tenant that, are you a high income tenant? And kind of say, here's what qualifies as a high income tenant. Do you have any sort of documentation to show that you either are or are not? But the caveat to that is that the tenant isn't obligated to tell you, and you can't go ask their employer, and you can't subpoena financial records or anything like that. So a landlord is kind of left in the dark as to whether or not a tenant, unfortunately.
Okay. So for tenants who are impacted by COVID, they, under this, have some time where they have a cushion as long as they provide reasonable documentation, it sounds like.
Right, exactly. And then high income earning tenants, they have certain documentations that they do need to provide if they are in fact one. So if you have a tenant who, they have high rent, that they have high income, they need to supply you with things like W-2s, income statements, any sort of letter from their employer, something like that says, hey, yes, I am a high income earner, but now I'm affected because of COVID-19 and my income has been reduced. And, so the state law is really hoping that landlord and tenant work together to really come up with some sort of either agreement, something along those lines, when it comes to those rents for March through August.
Right. We had someone who says, great topic. I think anybody who's dealing with real estate right now is kind of grappling with this, I mean, tenants who are impacted by COVID are, going, what rights do I have?
Right.
Do I need to pay? If I can't pay, what documentation do I need? And then landlords who have tenants who are impacted are also trying to figure out, okay, what can I ask for? What do I get? What do I need? How do I handle this? And so there's a lot going on, both with people who are impacted by COVID, people who can't pay rent. But let's shift gears for a minute. Let's say that you've got a property owner who has a tenant who is paying rent, and the tenant is not impacted by COVID. Thankfully, they have a job. They're a good tenant. They're paying rent. But maybe the property owner's circumstances have changed, and they, for financial reasons that may or may not be related to COVID, need to sell the property. Can they give the tenant notice now? What are the rules on that?
So yes, they can give notice on that, but keep in mind that we're talking about a month-to-month tenancy. If you're locked in a lease, you're still locked in that lease. That doesn't change, right? But if you have a tenant who's been there for a long time and your lease just keeps rolling over and it's month to month, nothing stops you from being able to give a 60-day notice to say, hey, I am either selling the property, or I have to do an owner move in where a relative needs to move in for whatever reason, or they need to move in. Nothing stops them from doing that. They're still able to do that. And there is still the exception to where if they've already entered into escrow, then you can do the shorter notice of the 30-day. But there's certain exceptions that you have to meet there, but all of that still remains the same. It's just that you have to make sure that you're doing it in good faith. So the real issue becomes if your tenant isn't paying rent and you give that notice, we need to be sure that you're truly doing it to sell the property or for an owner move-in. If that's not the problem and you have a good paying tenant and you give that notice, then it's very straightforward. You give the 60-day notice. If they don't move out, your recourse is to then file the unlawful detainer lawsuit.
Okay. But I know there were a lot of changes at the beginning of the year regarding landlords and noticing and evictions and whatnot. And I think that, I don't know if that's on your end or my end.
I don't
know. Going. Hopefully not mine, but we apologize for the technical difficulty. But I know that I think that the changes that occurred at the beginning of the year, and then the changes that occurred with COVID, have some people feeling that like they can't really do anything, like their hands are tied. And it sounds like that's not really true.
Not anymore. It was in the beginning. Perhaps it's my phone. I'm sorry about the technical difficulties here.
Bear with us. We are experiencing some technical difficulties.
Yes, I'm sorry about that. Is it working?
You're sideways now. There you go.
Okay, sorry about that. Okay, so before it was difficult. We had to show that there was a threat to health and safety, and that's no longer the case anymore for the most part. So now if you have a tenant where you're going to give a 60-day notice and say we have to do owner move-in, we have to sell the property, and that notice expires, let's say you give it this month, and we can now file in November, we can do that with no problems, with no additional motions or anything. It was much more complicated and restrictive before September.
Okay. All right. And so so it sounds like it's much easier for a property owner to give a tenant notice if they're selling, if the tenant is current on the rent, than if they are behind. Is that correct?
That's correct. Yes.
Okay. So, and what happens with COVID if you've got a property that's on the market that is, We are still getting a little bit of feedback on your end.
I know, and I'm not sure. I am on my phone, so I'm not sure if that has something to do with it.
It's a little better, maybe.
I think it might be my phone case. Sorry. Yeah, I'm going to right now. Give me just a second.
Okay. Bear with us. I need we're experiencing technical difficulty music or something. But anyway, thanks to those of you who are out there for joining us and for being now you're upside down.
Okay. Sorry.
This is how we know we're not on HGTV, because they would never have this happen, right?
Right.
We're a little bit to the side if you want to come down and center down a little bit and just bring that down and there you go. Over a little bit. There you go. You're good. Okay. So what happens if a property owner has a place on the market and it's tenant occupied? They haven't given the tenant notice. And maybe they're hoping to target, in fact, somebody who would occupy the property. But there's people who might want to or not occupy the property and keep the tenants. So that's why they haven't given the tenant notice. And but people are wanting to go in and see the property.
Right.
What are the tenants' rights as far as access? Because it's different with COVID, correct? As far as the landlord's right to enter the property, how does that change?
Yes and no. Technically, the law remains the same as it did pre-COVID, in that you give your notice for access and that your tenant has the right to deny access. But if in your lease it says that they have to provide access, it's now a breach, right? And your recourse is to evict. Well, in COVID era, they have a defense to that eviction because of COVID, right? So I'm giving you notice so I can come in, but if they say, no, I'm not comfortable with that because of COVID, then you're going to have a hard time evicting them for that reason.
And you're going to have a hard time entering the property.
100%. And what I've been telling clients is it's better to do an investor and have your realtor really geared towards an investor for you. If you have a problem tenant who doesn't want to give access. It's kind of far and few between, but there are the bad apples who don't, or those who are just uncomfortable, and that's okay. But if it's because somebody's uncomfortable, usually you should be able to provide some sort of, okay, let's work together. Why don't I pay for a hotel for the weekend for you to stay at? We'll sanitize, something like that. Every situation is different. And in this COVID era, you really need to be able to work with your tenants and see if you can come to some sort of agreement as it relates to access, if that's their issue. Sometimes they just shut down altogether and they're like, no, I'm not giving access. You can't really deal with that. But if it's COVID related, you really want to work with the tenant, and you should be able to.
Yeah. So you just have to maybe get a little bit creative and incent them and strategize and figure out what their concerns are and how to address those concerns in a way that would allow them to be comfortable and you to move forward.
Right. Exactly.
Yeah. Okay. And then anything else that was a big change as a result of 3088 or as a result of COVID that either landlords or tenants should be aware of, Linda?
Well, we talked about rents from March through August. So rents from September through January 2021, are treated differently. Those rents where you have to give the tenant notice and say, hey, you still owe this money. But if the tenant pays 25% of that monthly rent, then the 75% that is left unpaid now becomes a consumer debt, which you collect in small claims. And you could never evict them for that money that comes up between September and January. Now, the caveat to that is that the tenant has until January 2021 to pay that money. So let's say we give them the 15-day notice in October and say, hey, you haven't paid October's rent. And the tenant says, okay, I'll pay you, but I can only pay a portion of it. They have some time to pay September, October, November, December rent. And if they pay 25% of those rents come January, then your only recourse is to file in small claims for the rest of the money. Does that make sense?
It does.
It's a little bit confusing, but that's how they treat it.
My question is too, I mean, you know, we're midway through September,
Right.
and it looks like this put rules in place through the end of the year.
Yep.
And then what?
Exactly. So right now, the way that the law is today is that come January 2021, if your tenant doesn't pay 25% of that rent, then you can file a 3-day notice and proceed forward with the eviction lawsuit come February 2021.
Okay.
But if they pay 25% of the money for those months, you have to go to small claims court in March of 2021 for the remainder 75% of each month.
Okay. Well, I can see that you are probably very busy right now. Because even with your clear explanation, this is a little confusing for people who don't deal with this every day.
Right. And it's important that you seek legal advice, whether you call our law firm or you call another law firm. Another big issue that AB 3888 does is that it gives tenants protection that if a landlord doesn't follow these laws, a tenant can actually sue you and say, hey, you violated this law. I'm now entitled to money because you're chasing me for the money that I owe you. So it's important that a landlord doesn't be too aggressive, or before they get aggressive, they need to seek legal advice, because otherwise now there's laws in place that where you could be fined anywhere from $1,000 to $2,500 per instance of you violating the law.
Well, that's definitely something to be aware of, because I would imagine that them talking to you for an hour would be less than $2,500. I don't know. It's a guess.
Yes, it would.
That's where that ounce of prevention is well worthwhile. So,
right.
Anyways, thank you so much, Linda, for joining us. Appreciate your time and all the information. We'll make sure to, I guess, tag you guys or put the link and whatnot, and then you can share it. And again, we'll make sure that your information's there so that people can get in touch with you if they have additional questions. And I thank you for your time. So stay safe and stay healthy.
Right. Thank you so much. I really appreciate it. And I'm sorry for the technical difficulties.
You know what? It happens.
Yeah.
I blame
have a good
COVID,
day.
but I think it's the phone, right?
Yes, it's the phone. I didn't realize I needed Chrome. So.
Oh, okay. No worries. No worries. Okay. Thanks a lot. Take care.
Thank you.
All right. Bye-bye.